Hey everybody, Nick Espinoza, your chief security fanatic here, and today we actually have to talk about the United States because the United States may be getting its first national data privacy law. That is a good thing despite some reservations or some potential flaws in the bill. We're going to talk about that. This is coming from the Register, and here's what's going on, because America just took one step closer to getting a federal privacy law, and that bill is headed to the House of Representatives for debate after clearing early hurdles out of committee. Now, the House Energy and Commerce Committee on Wednesday, this past Wednesday, approved the American Data Privacy and Protection Act, or ADPPA, which would limit how companies could collect personal information and what they could do with your data. Now, the bill imposes a baseline, quote-unquote, duty of loyalty on businesses dealing with customer data, saying that they cannot collect data, quote, beyond what is reasonably necessary, proportionate, and limited to provide specific products and services requested by individuals. Now, the bill basically says it's up to the FTC, or Federal Trade Commission, to determine exactly what that means and what those limits are. The ADPPA also requires businesses to transparently ask and receive explicit consent for each piece of data collected, meaning Facebook and Google can't just vacuum up your information. They actually have to explicitly spell it out and then get your consent to do just that. Businesses can only use the data for stated purposes that consumers agree to. We just saw that with Twitter, where they said, oh, give us your phone number for multi-factor authentication, and then they were selling your phone number and we didn't know. So basically, they are talking about they can only use the data stated for purposes that consumers agree to, as I just said, and requirements are stricter for quote-unquote large data holders like the Facebooks and Googles of the world. The bill achieved a mostly bipartisan consensus with the Energy and Commerce Committee, voting 53-2 to advance the bill to the full House for consideration. A similar bill is currently working its way through the Senate, meaning we may see these two mix and match, something along those lines. Now, the only two holdouts on the committee were Representatives Anna Eshoo and Nanette Diaz-Barragan, both Democrats from California. And California, if you didn't know, has stronger protection laws than those contained in the ADPPA. Obviously, that's their issue. Representative Eshoo expressed concern that while the bill would provide privacy protections for Americans in most of the country, quote, I can't say the same for my constituents and all Californians. Ms. Eshoo, or Representative Eshoo, is correct in the sense that if you live in the state of California or a resident of California, you do have stronger protections than what this bill offers. Now, according to The Hill, the publication, Rep. Eshoo proposed an amendment to the bill that would make it a baseline standard that would allow individual states to impose additional restrictions, meaning while this goes into effect, the stronger California state law would be the law of the land in that state. Just like in Illinois, we have the BIPA here for biometric information, which is one of the most stringent in the nation, more so than what this is, and then Illinois would be able to retain that as well. The amendment failed to pass, though, during Wednesday's markup session that preceded the vote. So basically, it went to the House floor, or it's going to the House floor, I should say, without the ability for states to override it with more stringent laws. And so the million-dollar question here is, will this actually pass? Can the ADPPA actually pass? According to the Congressional Research Service, which issued a review of the ADPPA in late June, Congress regularly proposes federal data privacy bills that fail. So what makes this different from previous privacy bills is that it compromises and strikes basically regarding preempting state privacy laws and creating a right to private action, such as suing companies violating laws, instead of requiring the government to force them, meaning you now have the ability as a citizen to go after a company if it's found abusing your data, not having to rely on the federal government to do that for you, obviously lightening the burden on the federal government. The ADPPA in its current form would preempt state laws, as I mentioned, but preserve 16 categories of state protections, quote, including consumer protection laws of general applicability and data breach notification laws, end quote. It also allows for private action, as I just mentioned, but only after 4 years have passed, which I find interesting. A statute of limitation on suing for illegal data collection, that's an odd one. Now, the Senate version of the bill may be in trouble before discussions have even begun, with basically Senate Commerce Committee Chair Maria Cantwell saying the ADPPA ADPPA, had, quote, major enforcement holes. Privacy advocates have also expressed dissatisfaction with this version of the bill as well. The EFF, or Electronic Frontier Foundation, said that it was disappointed by the draft that passed the committee and noted 3 initial objections. The bill's overriding of state privacy laws, changes the EFF said would make it hard to enforce an existing federal privacy law that applies to telecommunications companies, and an abundance of exceptions written into the bill's right to private action. Obviously, if we have a right to privacy, we have a right to act on that and should not have to wait 4 years. I actually happen to agree with the EFF on all 3 of those charges. Now, compromises might be necessary, though. Representative Kathy McMorris Rogers, Republican of Washington, the Republican leader of the Energy and Commerce Committee, said in a statement that 80% of Americans reportedly support the priorities of the ADPPA. I think that number, quite frankly, is honestly higher. Walk up to anybody on the street that you don't know and basically say, hey, can I have your phone number, your social security number, your personal information, tell me what you had for dinner last night, et cetera, et cetera. But that's essentially what you're doing with Facebook or Instagram or TikTok, or take your point, or take your pick rather. They're just vacuuming up this information that we're blindly giving this out, whether we want our friends or our followers or anybody else in between to see. Understand that there are tens of thousands of employees on the back end of Facebook that sees all your stuff. There's artificial intelligence that sorts you into categories so you can be more effectively advertised to. We don't know how far this rabbit hole goes. And while there are states out there that have much more stringent laws, California has a CCPA, Illinois has the BIPA, New York has SHIELD, and on and on and on. This is a good start. And I mean that in the sense that while I think this bill needs to be honed, it needs to be more stringent, it needs to be, I think, more in line with the GDPR to ensure Americans' data privacy no matter where we go, meaning if our data is being stored in a data center in India, we should have the same right if it's being stored in Silicon Valley. And I think that's something that I'm not really hearing about this as well. The GDPR follows EU citizens wherever they go around the globe and enforces that law publicly. So I think something along those lines is needed, but it's a good start. We don't have something right now that enshrines Americans' data privacy. And even if this is weaker, we still need to get something done because it can be amended, it can be updated, it can basically be hardened in the future to protect you and I even more. I think the state preemption is a very important aspect of that. California has something like 40 or 50 million residents and citizens in that state, meaning those people are going to basically not lose their coverage, but have their coverage weakened if the ADPPA comes into effect. Not to mention the fact that the state governor or attorney generals might choose to enforce the CCPA over the ADPPA, in which case, okay, do we have a constitutional crisis here? How's that going to work? So I think there's room for growth. Obviously, there's room for improvement here, but we've got to do something because the vast majority of the states don't have anything like this, which means our fellow citizens aren't protected, like they are in a handful of states that actually have gone and had the foresight to actually put up privacy laws for their citizens. So there you go. I think this is a really important thing. We're going to see where this goes, but the ADPPA, despite its flaws, I think, is the right move at this moment because, as I mentioned before, congressional oversight shows that privacy bills come and go and they go nowhere. If we're actually able to get one passed, that is a win for the overall American people, even if it has flaws, even if it needs work. And as I think it was Obama that actually said it, perfection should not be the antithesis of progress. We need to continue to progress and progress more towards data privacy rights against the Facebooks and the Googles of the world. And so this may not be perfect, but we can continue to work on it. And in the meantime, we're that much more protected, or at least most of us are, compared to those few that have those protections per state. And please like, share, follow me here on Facebook and Twitter at Nick AESP, where hopefully they'll have to ask for your consent in the future. Same with YouTube, where you should follow me as well with your consent. And as always, stay safe, stay online, and please attempt to stay private, and hopefully this bill will pass. Take care.